Hello, everyone. Thank you to the almost 150 participants for joining us today for this roundtable discussion on the use of digital evidence in international courts. My name is Milena Stereo, and I'm the Managing Director at the Public International Law and Policy Group and the Charles R. Emmerich Jr., Calfee, Helter, and Griswold Professor of Law at Cleveland State University's Cleveland Marshall College of Law. I will be moderating today's roundtable, and I'm honored to be guiding the conversation with these experts. The Public International Law and Policy Group is a global pro bono law firm providing free legal assistance to parties involved in peace negotiations, drafting post-conflict constitutions, war crimes prosecution, transitional justice, and human rights documentation. In the past months, our team has been fostering the development of a thought leadership initiative. This initiative focuses on a range of topics, from prominent international law issues to pressing global conflicts. Through organizing periodic roundtables, our aim is to share expertise and reflections from our work on peace negotiations, post-conflict constitution drafting, and war crimes prosecution. In our previous Civil Society Documentation Roundtable Series event on the use of digital evidence in international courts, held on January 21st, 2022, we discussed using technology for documentation and how it is used and analyzed by courts for accountability purposes, exploring the relationship between documenters and the information they collect being used in international courts. Today, we will discuss how these same technologies protect the sensitive information that victims and witnesses provide to documenters and investigators, and the legal responsibilities that come on behalf of using them. Who owns the data? Where is it stored? How is it protected? During this roundtable, we will discuss how documenters who use digital databases store digital information and what their obligations are when it comes to protecting the sensitive details that victims and witnesses provide to them. We will seek to understand the data privacy regimes that govern this work and how they apply to documentation. Today's event is supported by our partner, Orrick, Harrington and Sutcliffe LLP, a global law firm. Orrick, headquartered in San Francisco, is widely recognized as the leading law firm in the area of technology and innovation. Orrick is a long-standing PILPG pro bono partner and has supported a number of our projects, including our work on creating a database for over 1,000 questionnaires and statements taken in the Rohingya camps in Cox's Bazar, Bangladesh. Today, we're also honored to be joined by Heather Sussman, who is the head of Orrick's Cyber Privacy and Data Innovation Group and is recognized as one of, if not the top expert in this field. The roundtable will be 60 minutes long. Our esteemed panelists include Heather Sussman, Matt Davis, Mistal Taylor, and Stephanie Monroe. Today's event will be recorded and subsequently posted on our website. We ask that you please submit any questions you have for our speakers using the Q&A function, and we will do our best to answer your questions at the end of this event. Now, please allow me to introduce our panelists. From Orrick, we're glad to welcome Heather Sussman, head of Orrick's Global Cyber Privacy and Data Innovation Group. She's ranked by Chambers USA, Chambers Global, and the Legal 500 United States as a leader in her field. Heather routinely guides clients through the existing patchwork of laws impacting privacy and cybersecurity around the globe. Heather also helps clients reduce the risk of privacy and security incidents, and in the event of a privacy or security breach, she helps companies respond. We're also pleased to have Dr. Mistal Taylor, Senior Research Analyst at Trilateral Research and Counsel at the Public International Law and Policy Group. Mistal is part of the Applied Research and Innovation team at Trilateral Research. She conducts research into law, technology, ethics, society for ongoing projects, as well as international criminal law and human rights law. Her areas of expertise include public international law and data protection law. We're also honored to welcome Matt Davis, visiting lecturer in law and researcher at Birmingham City University. He's also a visiting researcher at Free University of Berlin. Matt is Contra Nocendi International's executive director and has led many of the organization's interventions at international human rights mechanisms. Contra Nascendi International is a Paris-based international human rights NGO dedicated to promoting human rights and the rule of law in Africa that focuses on access to justice and the right to counsel, rights of women, children, and minorities, as well as sexual orientation, gender identity, and sexual orientation, and monitoring conditions of treatment and detention. He has spoken on panels ranging from leveraging data for accountability to access to counsel. We're also excited to have Stephanie Monroe-Courtney, the logistics coordinator for the PILPG investigation of atrocity crimes committed against the Rohingya in Myanmar's Rakhine State. She worked on PILPG's data storage and management during this documentation mission. Stephanie currently works at Wolf & Wyman LLP. She also continues to assist with various international human rights pro bono work. For full speaker biographies, please see the links sent in the Zoom chat and visit the PILPG website. Welcome, everyone, and thank you for agreeing to participate in today's panel. Without further ado, Heather, let me turn to you first. What do we mean when we talk about information security and data privacy? How are these concepts different but related? And how do we distinguish between concepts such as information, data, and personal data?
Thanks so much. And there's a lot to unpack there. And I'm so pleased to be part of this panel, and also just happy to answer any questions on the fly as we go. So I think about privacy as and cybersecurity or data security. They're really two different things. A lot of times people say privacy or security interchangeably, but when we talk about privacy, what we mean is typically when talking about an organization or a person who may be collecting personal information about privacy is really about and the law of privacy is, does the organization or the person have the right to collect the information that they're collecting, use it in the way that they propose, intend to, and in fact actually do use, and potentially disclose it. And so in thinking about the law of privacy, it's around, first of all, there's a type of information, there's personal information, which can mean different things depending on where you are in the world. Personal information is a term most often used in the United States, whereas the term under European law would be personal data. And so what we're generally talking about is information that can be used to identify an individual. So potentially a name, a photograph. And so laws around the world, and depending on which region you may be in, govern the collection of that kind of information, the use of that information. And the other aspect of privacy law that I like to highlight too is sometimes it's not just about information, right? It could also be about monitoring individuals. So monitoring behavior. We see this come up often in the surveillance context, right? Where it's either surveillance through cameras where you may be monitoring behavior in that way, but it's also potentially the surreptitious collection of information online through tracking technologies or otherwise. So so it's not just data privacy, it's also privacy, the right to be free from unreasonable searches and seizures, or the right to be left alone, the right to privacy in your own home and not be surveilled. These are all concepts that are grounded in the law and privacy. Now, I will often say privacy, and it's like a yin and yang, privacy and security. Privacy is typically grounded in a series of fair information practice principles, privacy laws are. And so the fair information practice principles are these commonly recognized principles around the world that address how individuals should be handling the personal information or personal data that they collect. And so the fair information practice principles generally or commonly can be reduced to about 5 or 6 different themes, depending on how you break them out. And the first is really notice. It's providing individuals about whom you may be collecting information, notice and information, and being transparent about how you're presenting that information to individuals to share with them, how you're what you're collecting, how you're using it, to whom you might disclose it. There's also these concepts of data minimization and storage limitation. So you provide them notice, but data minimization, storage limitation, you're only collecting the minimum amount that you really need in order to accomplish the business purpose. And you're limiting from a storage limitation standpoint, you're only keeping it then as long as you reasonably need to carry out that business purpose, and then potentially destroying it once that business purpose expires. There are also concepts like use limitations. So if you've specified in your privacy notice what you collect and how you use it, privacy laws say, well, then use limitation, you're really limited to your uses of the information to that which you've specified in your notice. And then, of course, this concept of security, which I've touched on a few times, right? So you can't really keep information private unless you also keep it secure, right? So security is actually a fair information practice principle grounded in privacy law. And so I'll often say that you can have security without privacy, right? Some government surveillance might teach us that. You can have security without privacy, but you cannot have privacy and privacy compliance without security. So why don't I pause there and see if you have any follow-up questions or any others want to jump in with their thoughts.
Thank you for the very comprehensive answer, and I'm sure we'll return to many of the points that you just raised. Ms. Stahl, my next question is for you. There are numerous data privacy regimes around the globe. Can you please give us a brief overview of at least some of these data privacy regimes, and are there major differences between them?
Yeah, sure. And thanks as well for having me on this panel. So what's interesting about data privacy is that even though it's not a new concept, it's relatively new and it's relatively newly codified in the law, and it's wildly different in terms of which jurisdiction you're in and which country you're in, which makes obviously a big difference when we're documenting human rights atrocities, violations in lots of different countries and jurisdictions. So the kind of narrative that's generally given is that it was somewhat born, even though the concepts existed, the kind of codification of what we now call data privacy law was born of these fair information practice principles that Heather mentioned in the US. And then almost simultaneously in the early 1970s, there were some European states, so within Germany, Sweden, etc., that started to codify their own data protection using that term, laws. And then this spread, and there was the OECD guidelines in 1980. So there started to become some regional frameworks. There was a Council of Europe Convention also in the early 80s. So you started to see some kind of harmonization amongst certain regional groups of their data protection laws and approaches. And then what this culminated in was the 1995 European Data Protection Directive. So this was an EU law applied in all the member states. And it has since been rewritten and really extended and implies a lot more enforcement obligations, a lot more obligations on companies and entities that process personal data. And it started applying since 2018. Why this is important is because it arguably sets this golden standard of data protection. So it's got extraterritorial effect. So when we talk about certain data protection obligations for people in third countries or on the ground in non-US, non-EU jurisdictions, they might have certain obligations that would meet these requirements laid out in the GDPR, or at least ratchet up to that sort of golden standard. It's got a wide territorial reach. And then if we're talking about kind of the rights that these individuals enjoy, the EU rhetoric is very rights-based rather than seeing these individuals as consumers, they're kind of rights bearers. And in this humanitarian example, you can think of the beneficiaries as beneficiaries of that aid rather than consumers or enjoyers just of this data protection law itself. So if we kind of think of this rights-based framing, at least from the European tradition, that can help inform how we deal with these documenters on the ground.
Thank you. My next question is for Stephanie. Stephanie, you were engaged with documentation work and the storing of data during the PILPG investigation of crimes committed against the Rohingya in 2018. Can you talk to us about some of the decisions and challenges that you had as the logistics coordinator for the documenters regarding privacy concerns in your documentation work?
Sure. So, I mean, I think what we've just heard is a theme that you're probably going to hear throughout this conversation today, in terms of there's a golden standard, there's an ideal that we're all striving towards, and then there's the reality that we face when we're on the ground for a documentation mission. You are making decisions very quickly, sometimes with limited information. So how that came into play for the Rohingya documentation mission was kind of twofold. First of all, the original idea had been to operate with paper questionnaires in the camps, and that was just a necessity given the technological issues on the ground. But the concept had been we would have the investigators use these paper questionnaires in the camps, return, and then a core group of us would actually code and transmit the information back to the team in the US via tablets. And once we got on the ground, it was clear that we had some real concerns about transmitting that data. And so the decision was made once we were in the field that we were going to stick with just paper questionnaires, which poses a unique set of concerns when it comes to sensitive information that you're controlling. So for the Rohingya documentation mission, we had over 1,000 questionnaires. Those are multi-page questionnaires. Obviously, we were not going to carry multiple thousands of pages from the US to Bangladesh with us. So we had to come up with a system of how to print the questionnaires in Bangladesh and do so in a way that recognized that even though these are blank questionnaires, they're still not something we want to be showing off. We don't want to draw attention to what we're doing. So for us on the ground, that meant that the advanced mission had to find a printer in Cox's Bazar, Bangladesh, find ink, which this was the first time I've ever worked with powdered ink before, and print 1,000+ versions of this questionnaire. How do you store that, even though it's not completed yet? The way that we did that was to kind of store it in different advanced team hotel rooms in their safes. And things become more complicated when you have the investigators on the ground, because now you're handing them these surveys to be used in the field. I would give them maybe 10 each day, depending on how many interviews we expected them to do. They're going into the camps. Now they're filling in the surveys. That's a lot of moving parts, because when they come back at the end of the day, let's say they completed 6 of the questionnaires. I've got 4 uncompleted questionnaires, 6 semi-completed questionnaires. And the reason I say semi is the reality was you just didn't have enough time during the day to take in the information from the person you were interviewing and code it so that when you got back to our base, you could kind of hand me the completed questionnaire. So at the end of the day, I had investigators taking semi-complete questionnaires to their hotel rooms. So now you're trying to manage who has what, how many questionnaires are floating around. And obviously there's people's stories on these questionnaires. It's pertinent information, it's names, it's details of what happened to them. So that is what I mean in terms of there's a real struggle when we go into some of the places that we're going and we have to operate, especially with paper. How do we best protect the people that we're working with?
Yes, thank you. I'm sure it was a challenge, and I'm glad you're able to share some of your experience with us today. My next question goes back to Heather. Heather, despite the different legal regimes, as Ms. Dahl outlined for us, are there any key data privacy and information security principles that every documenter should abide by that conform to the highest standard? As Stephanie said, we all strive to abide by the highest standard. So what are some of these key principles?
So I laid out the 5 privacy, the fair information practice principles at the outset. One of the most challenging for data collection in the field, I think, is notice, right? It's providing notice. You're not going to pull out a traditional privacy notice and expect someone to read it and necessarily even have it in the language that you may need to share it. So in that context, then I think that being transparent in the conversation with the purpose that you're there, which I think is probably the natural flow from the conversation anyway, why you're there, what you're collecting. But you could also work into the conversation explaining, for example, Stephanie, what that questionnaire is and how that information is going to be transmitted back to the United States and made part of the overall record documenting their experience. And so instead of handing them that formal privacy notice, orally being able to communicate this information and then be able to refer them if someone has questions or they want to learn more. The key principle, and I think so much of what you said, Stephanie, really touched on this, is that the principle of data minimization and storage limitation, right? Only collecting that which you need. But this is a voluminous questionnaire, and there's potentially a lot of information on there. And so then it really goes to guiding the construction of the survey, that questionnaire, which clearly so much thought went into that. And really gathering the limited amount of information that you need in order to meet the purpose for which you're collecting it. And the security principle, of course, as well. And Stephanie had some great suggestions there. We're not just talking about cybersecurity, right? This is actually physical paper security that you're dealing with, and how to protect those records equally with the others, equally as if it were in an electronic format. So I think there are field challenges for sure. And I think your experience in describing some of the tactical solutions make a lot of sense. Now, when it comes to security, we've talked about the privacy principles. The securities, the principles around security are really grounded in various frameworks around the world. In the United States, for example, the National Institute of Standards and Technology, known as NIST, puts out a cybersecurity framework. There are other, the CIS controls, computer information security. So there's a whole series of different articulation of security requirements around the world, but generally physical security is one aspect of it, right? Lock and key, perimeter security. So it may not just be locking the safe, but also locking the door in which is behind the safe. So you've got multiple layers, a defense, it's called a defense in depth strategy for security. And typically what you're focused on are access control. And so there's a number of different ways to control access. And then if you're storing the information, I'll always say, follow the data, right? Follow the data along its life cycle and think about security at each of those stages. If you're taking that information and transmitting it through your tablet back to the United States, what kind of security do you have on the tablet? And then as the information is in transmission, can we be encrypting or password protecting it? And really thinking about the data flow as it travels through its life cycle and ensuring security at each point. When it finally gets to the United States, you've taken all these precautions to collect. Where are we storing it then in the US? Is it just sitting on a box or a cloud repository? No, of course not, right? We're locking it down in terms of even its electronic storage and transmission. So I'll pause there. I hope that gives you some answer to the question.
Yes, absolutely. Thank you. My next question is for both Matt and Stephanie. Both of you have been part of documentation missions and have managed large amounts of data collected during these missions. As you know, there are certain legal standards that information collected by civil society has to meet before it can be found admissible as evidence in a court of law. However, digital documentation efforts are also governed by other laws, including privacy laws, as Heather just described. Is there a tension between the demands of two different areas of law? And let me begin with Stephanie, and then Matt, you can jump in as well. Stephanie.
Yeah, I think there's certainly a tension, and part of my answer, I will say, I'm repeating what Heather said to a certain extent because she took the words right out of my mouth. But there's a tension between the information that you need to ultimately deem something admissible in a court of law. So at bare minimum, who, what, where, when, why, how, and the work that we're doing as documenters sometimes in the field, in the sense that you are gathering the information that you need. If you are doing a mission to gather evidence that you ultimately want to use in a prosecution, for example, you have to ask those probing questions of the individual you're speaking with. And I think one of the core tenets for any human rights documenter is do no harm. You're asking people about what was arguably the most traumatic experience in their life. And if you're trying to gather information to be used for a prosecution, you're asking some really tough, traumatic questions to the person that you're speaking with, potentially. So I think the most important thing there is everybody has to go into it with eyes wide open. You need to be upfront with the person that you're speaking with about what the purpose of the mission is, why you're asking the questions that you're asking, how you intend to use that information, they need to know that years from now, this information could come up during a trial. They could be mentioned. For a lot of the people that we work with, they may have found some temporary security, but they are still at risk. So they need to know what information you're taking about them and how you plan to use it. So I think there's a real tension there between kind of the legal standard, which we want to be demanding, right? We want the who, what, where, when, and why. And what our goals are as human rights documenters. We don't want to subject the people that we're talking to that standard all the time. So everybody needs to know what the goal of the mission is. And as a human rights documenter, you need to know what your mission is. Are you gathering information for potential prosecution? Or are you gathering information just to gather information and start a conversation about something that's going on? That'll really guide you.
Great, thank you, Matt.
So yeah, I think Stephanie kind of hits on a lot of points that are important, especially when it comes to the type of information you're gathering and the people you're engaging with, because one of the issues that you can deal with when you don't do it the right way, you can almost magnify the negative impact that they're feeling from this when they feel like, they've told you your story and then they see it afterwards and like, I didn't know you were going to use it that way. And that kind of breaks trust. But what I would say too is, yes, there is always going to be a tension, but when you deal with a lot of things, you think of human rights law, for example, you're not just looking at international law, you look at domestic law. So you're going to have different sources of law that you're going to have to worry about, and you're going to have to work through them. And I think one thing that we've tried to do, and I would encourage others to do, is kind of be proactive when you're doing this. These aren't conversations that you have after you've started collecting data. What you want to do is start thinking. It starts with simple things, such as having a proper data protection policy in place, not just for when you're doing work in the field, but anytime you interact with someone, because that kind of encourages a standard of respecting people's privacy and thinking about that. For example, you might get an email where an organization wants to see if they can work with you. They may send you some private information or stuff that maybe they haven't kept completely private, but they're not advertising about what they do in the field. You might have someone who sends their CV. These things are still issues of data protection. And if you kind of set that framework beforehand, you kind of create I guess you can say, an organizational culture that cares about data, that understands that these things do matter. And I think that that's part of it, is that you do that, and that you also kind of reinforce these notions of, like what Heather was saying, that going point to point, from the point that you collect the data, or you even start engaging with the individual you're collecting data from, to the time it's stored, to the time you transfer it on to whether it's the African Commission or the African Court or the ICC or ICJ, whatever it is. I think that that's the important thing, is to be more proactive in it and making sure you have a proper framework in place before you even start collecting the data in the first place.
Great, thank you. Now, Matt, how does your organization, Content Ascendi, ensure compliance with these obligations? And is it something that your team has to regularly stay updated on? And what are some challenges that your organization faces when storing and protecting data? And do you believe that storing digital documentation is preferable to relying on solely witness testimony and pen and paper questionnaires? So I know that's a lot, but here are some thoughts and questions from me based on your experience with your organization.
Sure. So when it comes to ensuring compliance, I would say that when it comes to the policies you've put in place for data collection in the field, at the end of the day, it's still an organizational policy, and you should be reviewing these all the time. So it's not just what you put out, it's about having this thought process. Can we do it better? Are we actually ticking the boxes? Has there been new law that's been passed that we have to take into account? And also too, when you do this through the review process, you're also reviewing the way you give disclosures to people in the field. Are we explaining it properly? Because I can explain this to my person who's a head of our office in Cameroon. He's a practicing barrister. He understands this stuff, but some of the people he deals with may not have the legal background. They're the non-expert consumer of information. So there is that, but you also need to be we try to be at least a consumer of information, I can say. Is so panels like this, not just on data protection, when you see the OSINT panels and things like that, there are things that other work that is done that raises some data protection issues and raises some compliance issues that we pay attention to. So I think that's a big part. And the other thing is that not just having these policies, but putting them in place. So when we bring in new staff, that have started doing our work on the field, we don't just say it once. We don't just have an initial training. It's a repeated thing that we kind of say, this is the expectation. In terms of what kind of issues we face in the field, I think the biggest one, especially in Cameroon, is internet reliability. It's very difficult to be able to communicate digital data when, my head in the office kind of jokes that he kind of gets his yoga exercise sometimes when because he has to contort himself to get a good internet signal. And so you can't necessarily convey stuff digitally when you don't have an internet connection. I think that's a big part of it. The other part that they deal with is just access. The one thing that we've seen, especially with the pandemic, is that there are some legitimate concerns about letting people in detention centers when it comes to controlling, the pandemic. But then you also see that it becomes an excuse to not allow any kind of access whatsoever. So it can be difficult to actually conduct documentation when you can't actually get into the facilities you're trying to get into. But yeah, I would say that that's kind of what we try to do, is what we kind of face is these issues that come through it. In terms of, is digital documentation better? Yeah, we've actually been working on making ourselves more digital. I think, Stephanie's example of trying to send 1,000 surveys, you can't just put that in DHL or something like that and post it over. That's very difficult. But the other thing that comes with digital documentation too is that you can kind of link it to tools that'll let you create visualizations of what trends you might be seeing, especially when it's anonymized. So because you can't always get photos, and you always want to show that at the end of the day, these people you're talking about are people, and sometimes you don't have that picture that can show that. But being able to show this in numbers in real times, and being able to show trends, especially when you're trying to prove, for example, that there's a systemic effort or a systemic behavior that, for example, in detention centers where we see where certain individuals are more likely to be exposed to what might amount to inhumane or degrading treatment, we want to be able to illustrate that in graphs or maps and things like that. And it's a lot harder to do that when it's written down. But at the same token, we are kind of at the mercy of detention center governors when they say you can bring a pad and paper in, you can't necessarily do the digital documentation when you have to leave your laptop or your tablet in the car.
Thank you, Matt. Heather, do you have any other thoughts, anything to add? And also, I'm going to turn to one of the audience questions, and maybe you can address this one as well. And the question goes as follows. How do these principles relate to group data, for example, geospatial analytic data collected in humanitarian or human rights contexts?
Yeah, so privacy laws and these fair information practice principles that we're talking about generally apply in the context of personal information, right? Personal data about individuals, humans. And so to the extent you're collecting group data, if it's comprised of data that would identify an individual, the principles would apply to that type of data. But there is a process and a way to de-identify data, to aggregate data, to pseudonymize data, which is giving data often key coding as one technique to ensure privacy protection. We see this a lot in the clinical trial space. There are many different techniques that can be applied in order to de-identify, aggregate, or render personal data sufficiently group group or aggregate level that you can potentially anonymize the data. So anonymized data falls outside the scope of these privacy laws that we're talking about, but to the extent it's anything else, including pseudonymized data, would still qualify as personal data that is subject to privacy law and these fair information practice principles that we've been discussing.
Great, thank you. I'm going to now also turn to another audience question, and I'm going to direct this one to Ms. Stahl. So you can take a stab at this, and then if anybody else wants to jump in, please go ahead. And the question is as follows. To what extent is the GDPR applicable to visual documentation processed in the EU, but collected in the field by first responders in war zones during their emergency response? And then in parentheses, for example, civilians appearing in the video were not consulted due to the circumstances of the emergency response. And if you can actually just give sort of a minute, very brief overview of the GDPR for audience members. I think most people are familiar with it, but if you can just explain quickly what it is, that would be great.
Okay, sure. Well, I'll start with the second part of the question of what the GDPR is. So it's the General Data Protection Regulation. So it's the EU-wide regulations are harmonized at a member state level that delineates what entities, so data controllers or data processors, are obliged to do when they're collecting personal data, so related to an individual, not necessarily that big data that we just spoke about. So anything related to an identifiable or identified individual. So it sets out all the legal requirements for processing that. And because it's got this slight extraterritorial effect, then there are a lot of countries that have in place very similar laws to the General Data Protection Regulation, GDPR. So in terms of the obligations with this, this visual data collected in the field, I think it would depend on where it was collected. So essentially the GDPR could be applicable if data was transferred between an EU state and a third state, so a non-EU state, and if there was an adequacy agreement, which means that that third country where this data might have been collected has an essentially equivalent level of protection to the EU. And it's the EU that kind of decides that or assesses that and gives that adequacy decision. So if that is in place, then the transfer of data between the two is fine, and that visual data that was collected would be subject to those same protections as offered in the EU. But there's also a wide general territorial scope of that regulation. So you could have an organization that's based in the EU or outside the EU that targets people in the EU. So maybe offers its services, or like Heather mentioned at the beginning, maybe monitors people in the EU. So in that sense, it would be kind of caught. So they would be caught by the regulation. In terms of collecting data abroad and then bring it into the EU, then it would also enjoy those GDPR protections.
Maybe a question too, Elena, if I may, is that when talking about these types of videos, and yeah, the individuals who are unwittingly collected in the background may not have even been known that they were recorded. So there are a number of different techniques that can ultimately be used to help ensure privacy, right? You can have, there's technology that can blur faces in the background where you don't have the consent for the video permission. But I would say that there's really a balancing, because those technologies can be really expensive, and especially in the NGO context, right? You might not have the budget to be able to afford such extensive technology. And so what I would say is that the GDPR has grounded within it this concept of balancing, right? Balancing the individual privacy rights with the needs, the legitimate business need you may have in processing information's concepts found throughout GDPR. And I would say that look, the goal of this law is not to frustrate very good public policy purposes, but rather to come up with some construct. So if you can't get the permission to use those individuals, I would say make sure that you're not then publishing the video, for example. You're using that video solely for internal purposes. And if you do need to publish it, say, Stephanie, you want to enter that as a piece of evidence in a trial, then at that point, you might have to obscure the other faces, for example, as one technique, because it will become part of a public record. And so the sense is that as long as you go through, we call these risk assessments, where you're evaluating the privacy risks to the individual and putting in place compensating or mitigating controls to address those privacy risks, you're often going to find yourself on the right side of the GDPR.
Thank you. Thank you so much for the clarification and kind of follow up there on the GDPR. There's another audience question that I would like to pose to our panelists, and it's as follows. Many organizations might be documenting to better understand what is going on the ground. That does require a wide net when drafting a questionnaire or survey, which is difficult to square with data minimization. Do the panelists have any advice on how to balance these two apparently clashing goals in practice? And let me start with Stephanie and Matt, and then Heather and Mistal, if you have thoughts on this, please feel free to jump in as well.
Sure, I can start with that. I think it kind of goes back to what we've talked about before in terms of what the goals are of your mission. So even if you're gathering information, I think you need to have a very clear sense of what information you're trying to gather. What is the purpose of the information? For example, are you trying to gather information about atrocities that have potentially been committed? Are you trying to gather information of where people have moved because of experiences they've had? And you can really tailor a questionnaire to that to a certain extent. You can make sure you're asking the questions that are really pertinent to the information you're trying to get. The challenge, I think the person who asked this question is right on point in terms of where they're thinking things through. The challenge is when you start asking questions, you oftentimes think of more questions you want to ask, right? You get a response and you start thinking, oh, I kind of want to probe down this path. That may be something you need to bear in mind as a documenter going into the field in terms of, okay, I may get answers that I'm going to flag for next time for a follow-up mission with a different questionnaire, a different purpose, so that you are limiting the information you're collecting at any one time. And it really depends on what the goal is of the mission. And I know I sound like a broken record with that, but I really think it's a key principle. You don't want to gather information that you don't need to gather. But at the same time, oftentimes when we go into the field, that's not an easy endeavor. We're not just, going down the street, right? There's a lot of planning that goes into going around the world, getting investigators into the field, prepared for a mission, interpreters. So you do want to have a wide-reaching questionnaire. You want to make the most of your time on the ground. But I think you want to be mindful of the risks that you are maybe opening yourself and the people that you're talking to up to by gathering all of that information.
Thank you, Matt.
Yeah, I think I would agree. I think that caring about scope and caring about making sure you're narrow with your questionnaire and the questions you're asking is important. I know that especially sometimes when we go out, we will go to a detention center that we don't necessarily get access to. So you're worried about, if I talk to this person once and I don't keep asking follow-up questions, I may never speak to that person again. Or, there might be certain questions I can't ask. Can I ask something else? But I think having a proper process in place and knowing what you're going to ask before you get there, for all the points that Stephanie raised when it comes to, you have to move a lot of assets sometimes to do that, but you also don't want to overstay your welcome when you go to a detention center. If it comes to the point where you're not just asking objective questions, you're starting to probe and see what you can find out instead of already having a questionnaire that you're going to go through and hopefully be more objective. At least maybe that way you can, open the door for next time. But I mean, I completely appreciate the concern the person who asked the question has. It is rather difficult to kind of narrowly define a questionnaire. It's just one of those things where you do have to really identify the issue you're trying to tackle and also understand the situation on the ground, what is possible, what is not, and what kind of resources you do have to move into place or use to be able to do that. And then, try to make your best judgment, I would say.
Great. Heather or Ms. Stahl, any thoughts on this? No. Okay. My next question then has to do with protecting individual documenters and then also victim and witness protection. So my question goes as follows. How do these data privacy law and information security requirements protect individual documenters? And what about data privacy law and information security requirements to enable victim and witness protection? Heather, do you want to start?
Sure. I mean, to the extent these are individuals, right, their information would be subject to these requirements that we've been talking about. So I think their status and how they're treated under the law can differ depending on which jurisdiction we're talking about. So for example, in the United States, some privacy laws actually don't cover employee data, believe it or not. That's not the case with GDPR and with GDPR-like regimes around the world, including in Brazil and in other places. But I think everything that we've been talking today could apply equally to protecting individual documenter information and also equally to protecting victims. I would say we talked a little bit about some of the different types of sensitive information, and there are these two concepts in privacy law, not just ordinary personal information, name, photograph, but also the potential for more sensitive information, whether it's potentially a photograph that indicates something that is revealing a particular or particularly sensitive in nature, biometrics, precise location information. And there's a series of, and depending on where you are in the world, different information treated as special categories of information, like Article 9 of the GDPR, which include things like race and national origin, gender identity, some of the things that you talked about earlier, Melina. And so generally, when you're talking about ordinary personal information, the protections that apply to that data are usually a little more ordinary. It's these basic fair information practice principles that we've been talking about. When talking about the more sensitive information, then often you think about it as requiring more sensitive protection, right? Heightened protection around that information. And so in many respects, how you're protecting documenters and the information you're collecting about them may be, something that you would not have more sensitive information about those individuals. And so it's more of the ordinary protections. But with respect to the victims and the individuals providing their live testimonies, you may very well have much more sensitive information that you're collecting. And so be thinking about it in terms of developing your level of protection to match the sensitivity of the data.
Great, thank you. Ms. Stahl?
Nothing beyond the same that, the documenters themselves would enjoy these data protection rights. I think it is interesting what Heather brought up about the sensitive data or sensitive information, because that's probably more likely to surface or be of concern when you're documenting human rights violations or atrocity crimes. And then at least under the GDPR regimen, there's actually a prohibition on collecting that data. So you need to have an exception to that, which might be for the person's vital interests, for instance, or if they've given some form of explicit consent, which might be difficult to get in these instances. So you need that exception to the prohibition, as well as a legal basis, which might be something like legitimate interests, etc. That's getting into the technical legal side. But I think that, and maybe that's a question for Matt and Stephanie, how do you deal with this sensitive information or a situation in which you suddenly realize a heightened level of protection is going to be needed?
Stephanie or Matt?
I thought too, as they're thinking about their answer, that you had in our notes for this session too, Melina, there's a great link to a handbook. And I wonder if we drop that into the chat here so that folks can take a look at that resource, because it is quite comprehensive. So it's just one that addresses some of these issues and could potentially be a good framework for thinking about data protection in the field.
Thanks. We can definitely drop that in the link in the chat. Thank you so much. Stephanie or Matt, any thoughts on this? No? Okay, let me move on to another question. And this one is in particular to Matt and Stephanie. From your experience working with paper questionnaires and digital documentation databases, what do you think are the pros and cons of each? And do you think that documenters are moving towards one or the other in the near future? Stephanie, do you want to start?
Yeah, sure. I think that there are, as you say, pros and cons to each. I mean, a lot of the work that we do, the places that we're going, there just may not be the ability to necessarily capture things digitally in some regards. For example, in Bangladesh, when we were working in the refugee camps, there were certain laws about sat phones, for example, which it seems small, but that made a big difference with our mission. So that was part of the reason that we were working with paper questionnaires there. So there's a pro in terms of a paper questionnaire allows you to work in circumstances and areas where digital transmission just may not necessarily be possible. As the panelists were talking about earlier, even around the world and in the United States, sometimes internet fails you. But there are definitely pros to working with digital data. I mean, as we talked about with regards to the Rohingya mission, just the sheer number of questionnaires we were dealing with, the information that we were dealing with, and specifically with that mission, ahead of time, we came up with a list of codes that we expected investigators to be using in terms of characterizing some of the atrocities they were hearing about. And as we were in the field, the number of codes increased dramatically because we were hearing stories and gathering information about, quite frankly, types of atrocities we could not have imagined. So that becomes a challenge too. And that's where I think that digital storage or digital transmission would be helpful, just with the sheer number of things you're dealing with, and also with things that are changing very quickly. You know, we had codes built into the questionnaires, but they were changing while we were in the field. And because we had paper questionnaires, we couldn't quite keep up. So there are pros and cons. One thing that is admittedly not my area of expertise, but was something that we had to consider on the ground, was in transmitting this data, what are the risks involved in that transmission? I touched on it a little bit in terms of the initial plan had been a hybrid mission of paper questionnaires and then transmission of the digital data back to our partners in the US. And we had to scrap that idea because of some concerns we developed during the first couple of weeks on the ground. And so that's a challenge that a lot of times, you know, the documenters that are going into the field, we're not experts on digital transmission. We don't necessarily know all of the risks involved.
Great, Matt?
Yeah, I think there are some trade-offs for both. I also don't think it's a mutually exclusive thing that you can only use digital and paper and not both. Sometimes it actually is kind of useful when you're dealing with especially socially sensitive information. For example, when we recently had a team go out that were dealing with women who had been exposed to gender-based violence. The issue with the deployment was it was two men who were out doing it, and to try to build up that trust, being able to stick your phone or stick your iPad in their face and record them is not something you want to do. And you want to build that trust because you want them to tell the whole story, but we also link some of our work to our law clinic as well. And we're always thinking about that. We're potentially building that attorney-client relationship as well. So you may want to do the written thing. I for a lot of reasons, I do like the digital tech, but it's not always very easy to do for a lot of reasons, unstable internet. And then sometimes when you may not have the ability to type down or write down right away. Sometimes we've had some of our team out and just noticed the use of force by security forces, and they're jotting it down. You're not going to stand there with your iPad when you see security forces attacking university students. You're not going to sit there and continue to video that. You're going to write it down. So there is the ability to kind of use both, but I think even when you do have it written down, you also have a different set of dilemmas and issues when it comes to digitizing that documentation, transferring that information, and trying to make something of it beyond just numbers or specific, but trying to use that to show trends over time, and then trying to raise that to a human rights mechanism.
Can I say too, I just wanted to follow up on some of the points that they made, which I thought were so powerful in the context in which you might use, digital versus paper. And it makes me think, as a privacy and cybersecurity lawyer, one thing I think about is third-party risk management, right? Like using vendors, using technology providers who can actually help to ensure a level of security, who can help to give the guidance. Stephanie, yeah, you're in the field, and you don't necessarily know that, what are the risks of transmission. So being able to tap into your networks and find trusted partners, and generally it's the trusted partners are technology partners who have, in many cases, also able to provide services at lower reduced cost, depending on the type of organization receiving them. But I would say, don't be afraid to ask questions. I handle and work with technologists a lot, and they'll say, maybe a chief information security officer or something. And I will always say that the techies, no, the lawyers will defer to the techies, but the techies never defer to the lawyers. It's like, sometimes that can be really intimidating because it's this whole area that you might not know anything about. Information security, what does that mean? And password encryption, and I have no idea, but ask questions and don't be afraid. You're not going to sound stupid. Most of us don't know the answers. And I've only learned a lot of this stuff on the job. And so being able to ask about that, the information flow, and now walk me through the steps of how it's protected each along the way. And don't be afraid to ask and unpeel those and unpack some of those, some of those mysteries, because I think it is just going to help arm you to make the process that much more secure and safe.
Thank you. And we have time for one last question. So it seems to me that data privacy information security is an evolving field. Would you agree with that? And do you see any gaps still? This law is evolving. Where should it go? How should it evolve? I understand that's a lot to unpack in 4 minutes, but Heather, would you like to start?
Well, I'll just, from my own perspective, I think we in the United States are further behind in terms of adopting a comprehensive privacy regime. We've got HIPAA, which applies to healthcare institutions and providers. We have the HIPAA equivalent in the financial services context, GLBA, banks and hospitals. But financial institutions and healthcare institutions are not the only ones that process information that needs to be protected. And so I do think it's a gap, but we're starting to see that addressed more at the state level in the United States. Generally, though, those laws are directed at for-profit entities as opposed to nonprofits. In contracts, GDPR and GDPR-like regimes apply pretty evenly across the board.
Thank you. Ms. Dahl?
Yeah, I think there are lots of gaps, and it is indeed a really quickly evolving field. And I think a lot of that is to do with the fact that the technology is really quickly evolving. And Matt and Stephanie have mentioned they use pen and paper oftentimes, but once you're doing digital documentation, then you've got this tech that can be so far advanced. And then the law, just as it does, is this slow beast that's slowly trying to catch up, or at least be written in a tech neutral way so as to be applicable no matter what is designed. And I think to kind of solve that going forward, the notion of having privacy by design and by default, or data protection by design and by default kind of built into that tech, so it's safe and secure, could be a way forward as the law is slowly catching up.
Great. Stephanie?
Yeah, I mean, I think one of the central themes today has been that this is and frankly, the reason we're having this conversation is this is an evolving field. There are no right and wrong answers at this point. And as we've pointed out, there are differing opinions throughout the world as to how we tackle this sort of thing. I think one of the challenges with that is the onus is really on us as documenters, as people in the human rights world generally, to keep up with what's going on and stay abreast of kind of what the developments are, what are people talking about. And so programs like this with PILPG, this is the kind of way to keep up with what's changing. Where are we going? What is it going to look like? So I think it's great for people to participate in things like this. I think that's at this point what we can do.
Great. Matt?
Yeah, I mean, I would agree that it's certainly evolving, and then having forums like this is good for trying to develop and understand how you can respect digital privacy and things like that, because a lot of times we see technology takes the first step and then the law tries to catch up. When I was listening to Ms. Dahl, I was thinking about several years ago when Mark Zuckerberg was before a congressional committee, and a senator asked him, well, how do you make money? They were that far behind, they didn't understand how a multi-billion-dollar company was making money with this technology. And I think that's kind of a good illustrative example of when it comes to this stuff, technology will go first and then the law hopefully catches up over time. So I think that having forums like this to have this conversation is useful, because it's not just about what you're legally required to do, it's what you think is the best step to actually protect someone's personal privacy.
Thank you. That's all that we have time for today. Thank you for joining us and submitting your questions. The webinar recording will be available on the PILPG website and also shared with all of the attendees on Zoom via email. This event was supported by our pro bono partner, Orrick Harrington and Sutcliffe LLP, and was part of the PILPG Thought Leadership Initiative series. Thank you very much to our panelists for taking the time today to share your experiences and expertise. And I encourage everyone to follow our Thought Leadership Initiative and join us for the next event, which will be next Friday, a week from today on February 18th. And it will be a conversation with Fatou Bensouda, the former prosecutor at the International Criminal Court. Thank you and have a great rest of the day.